Hello and welcome to a Pierro and Strauss live webinar, Medicaid Monday, the first in our 5-part series. Just a few housekeeping notes before we get started. We're sharing our webcam and your mics are muted. If you have questions for our speakers, please type them into the Q&A section on the bottom of your screen. And since we have a lot of information to cover in the next 30 minutes, we will email responses following the program. Our presentation is posted at the webpage pierrolaw.com/resources. Scroll down to the Medicaid planning area, where you'll also find our 2021 Medicaid guide. Finally, please fill out the survey. We would appreciate your feedback after the program. And now I'd like to introduce our presenters, Lou Pierro, founding partner, and Frank Hemming, senior associate attorney.
And good afternoon, everyone. Welcome to Medicaid Mondays, our first in a 5-part series. Today, we're going to cover general rules with regard to Medicaid eligibility and how to qualify. We'll then be going through a number of other topics. We'll get to those in a moment. But I want to tell you a little bit about Pierro and Strauss. We are a law firm headquartered here in the capital region of New York with growing offices in New York City and Long Island. We also have affiliate offices in a number of other locations, which you can see on the screen. And our new partners, Karen Kepler and senior counsel Harvey Schneider. Karen is a licensed attorney in Florida and New Jersey. In addition to our other affiliate offices there, she'll be practicing in those states as well. So to my left, your right, is Frank Hemming, our senior associate and chief Medicaid attorney at the firm. And I need to get that back. There we are. This is our agenda for today. Medicaid basics, the 2021 numbers, which they do change each and every year, how to qualify, what Medicaid penalties are and how they work, and then next steps in the process. So in the overall goal of estate planning, we have a number of functions. And our firm, Pierro and Strauss, is a boutique firm. We do estate planning, elder law, business succession, special needs planning, and litigation related to those areas. But in estate planning, we want to make sure we have the right people in place, and we do things like healthcare proxies and powers of attorney and wills and disposition of remains appointments. But one of the other goals of estate planning is asset protection. And when we do Medicaid planning, that really is that topic, asset protection planning, and making sure that you have enough money to live on and that the next generation maybe gets a little bit of an inheritance. So during the pandemic, obviously those of you in the long-term care field, you know that it's been very difficult to communicate with individuals in nursing homes and assisted living. Adult daycares are all shut down, but we have been able to operate as attorneys using video technology that was not allowable prior to the pandemic. So we can now do all of our meetings via either Zoom or Microsoft Teams, and we do those from initial consultation all the way through to document execution. We've had a number of document signings inside of facilities, being able to get powers of attorney and other documents signed using something as simple as an iPhone, not simple, but using an iPhone and FaceTime, and having the staff at the facilities work with us. So this is something that right now is temporary, month to month by governor's order. We'll see if it becomes permanent, but just know that we're able to do everything that we could do in the office now virtually, which, Frank, is a big change from what we had before. So in asset protection, the number one risk to everyone's financial well-being is health. Taxes have become an estate tax. We have an exemption now of $11,700,000. That does not pertain to most of us. But when we get sick or we need chronic care, the tax can be confiscatory because the cost of this care now is up around $15,000 per month. And if you do the multiplication, that's $180,000 per year for nursing home care. And Frank, there's only one program out there that pays for long-term care.
And that's Medicaid, right? It's not Medicare like many people think, it's Medicaid. So that's why we wanted to talk to you about Medicaid.
Yeah, and most people think in their years when they're doing well and healthy, I will never need Medicaid, and but for the need for long-term care, they're absolutely correct. But at $180,000 a year, not many people have private long-term care insurance or life insurance or sufficient income to get through this need for care. And home care can be just as expensive, if not more so. So all of this funnels. Do you want to be in your own home? Do you want to go to an independent community? Ultimately, you may need a nursing home. Who's going to take care of you? And finally, how will you pay for it? And that's today's topic and the topic for our next 5 sessions. How to pay for long-term care. And the only program, as Frank said, that's available for this is Medicaid. However, Frank, unlike Medicare, which everyone gets at age 65, Medicaid is a means-tested program. And so why don't you walk us through these numbers?
Sure. So whenever we talk Medicaid, we always talk income and assets separately because Medicaid looks at them separately. So if you're one person, individual applying for home care, like what we're going to talk about today, you get a monthly income allowance of $904. If it's husband and wife, or you both need help at home, you get $1,320 each month of your income. If we're talking about assets, again, if you're one person, it's $15,900 of countable assets. That couple doesn't double that number. They get an increase up to $23,400. There are 2 other numbers on the slide to talk about a little bit of what happens when you are applying for Medicaid and you have a spouse at home, when we have one spouse in the nursing home. We're going to talk about those a little later, so we'll get back to those.
Okay, so let's break it down and take a little more time with it. There's the $15,900 number. So for an individual, that's the amount of assets that you get to keep. So there are certain exemptions. And the 15,900 is the first exemption. You can have a bank account and you can have $15,900. And Frank, when you sit down with clients and walk them through the Medicaid eligibility, there are some other things that they need to be aware of.
Sure. So one thing that everybody likes to have just taken care of is your burial, right? At some point, everyone's going to pass away. So if you prepaid for your burial, or if you haven't, that's one thing that we do typically advise clients to take care of if there are funds available, is to prepay for that burial, because there's no cap on how much you can pay for that. If you have income producing property, meaning you have an active business, the asset of the business is exempt. The income from it would not be, but we can talk about that a little later.
Yep, and if I may, I
Go ahead.
did a presentation for the National Academy of Elder Law Attorneys twice, once at their national conference, and we did it by webinar. That's available. If anyone has a business or even rental properties, and you want to get Medicaid and you want to try to exempt that business or the rental properties, we can help with that. We can provide you with the information. I have an article that was published in the Naila News on that topic. We can make it available to you. Again, everything, questions, etc., info@pierolaw.com, and we will be responding to each of you following the webinar.
Another one is life insurance. So they look at the total amount of the face value of either the policy or the policies that you have. If you have more than one, the total face value has to be less than $1,500 for it to be exempt.
Not meaningful.
No. In 1965, that was the amount it cost to bury you. They haven't moved that number. So that's why that number is what it is. One car, regardless of its value. So you could have the junker car, you could have the Lamborghini. They don't care as long as you only have one. The biggest one on this slide typically for our clients is the IRA, as long as it's in periodic payment status, which automatically happens when you hit 72 years old, because that's when you're required to take your required minimum distributions.
But you can do it sooner. So if you're 70 or 68 and you need Medicaid, you can put your retirement account, your IRA, 401k, 403b, 457, you can put it into periodic payment status on a voluntary basis. We do that all the time for our clients. Also, the question comes up, well, what about a Roth? That never has a required minimum distribution. Can you exempt a Roth, Frank, under the same theory?
We have done that. We have basically set up those periodic payments, and so far the counties have exempted those accounts. So until we hear otherwise, we're going to keep treating them as if they were traditionals and take a little bit of income off them to exempt them.
So that's a lot, but these are the exempt assets. There's one more asset, and if you're thinking, well, what about the home? You're right, that may be exempt if you're living there and you're getting Medicaid home care, or you have a spouse living there, or a disabled child, or a minor child. Any of those living in the home retains an exemption. But if the home is vacant or you don't have any qualified individuals living in the home, then the home is an available asset. So we need to take steps to protect the home, and we have transfer exemptions to certain other individuals. We'll talk about that later in the program. We also have an ability, Frank, when you go into a nursing home, to keep the house off the table for a little while
Mhm.
by filing something called an intent to return home.
Correct. It's just a statement basically saying that you intend to return to your residence. So we do execute that, and we do file that with your chronic care application if we need to. The reason being that even though it wouldn't count as an asset for qualification purposes toward that 15,900, when you go into the nursing home and you file a Medicaid application for the nursing home, the county then can place a lien against your property. That intent to return home document is trying to not have that lien occur.
But the lien is going to occur even with an intent to return home. And then there is a recovery by the county against your home. So again, even though we can keep it off the table for a little while, if it's in your name, that is going to come to roost when you go into an estate you pass, and the Medicaid claim can be against that house in the estate. So we need to do some planning to protect the home. We'll talk about how that works in just a moment. Frank, this is broken down into two segments because Medicaid in New York is two very different programs. One of those programs is having major changes. The other has been the same since about 2006. So we're going to talk about nursing home Medicaid. And again, we have a subsequent 30-minute video just on that, webinar just on that, and home care or community-based Medicaid, and that's coming up in 2 weeks. But briefly, what are the differences between these two programs?
So the main differences are where you're receiving that care, right? Nursing home chronic care is in the nursing home. Community is basically any other place that you are, whether that's at home, that's in an apartment, that's in assisted living. The other major differences that we've seen are look back periods, if there is one, because up until last year, there was no look back for home care in the home, in the community, or in the assisted living. But there was one for the nursing home. So there's been a 5-year look back since 2005, 2006. That's still in place. And now we have this new look back coming into play for community-based benefits. And that's why we want to keep doing these webinars to get the word out about these new rules.
So we'll be covering this in more detail in 2 weeks, but the penalty, the look back period rather, for home-based Medicaid did go into effect October 1st. So any transfers made on or after October 1 of 2020 will be subject to a look back and a penalty for 30 months for Medicaid home care. New rules never existed before. What has happened is because of the pandemic and federal restrictions, New York State has not been able to fully implement these new rules. They were supposed to go October 1, then January 1, then April 1, then July 1, and now we're hearing that perhaps it's going to be pushed off further because the pandemic has not abated. So right now we have on the books officially July 1, but again, that may push back. Maybe in 2 weeks we'll have more information on that, but know that these rules are different. So Frank, for our nursing home and soon to be for Medicaid home care applications, not until the new rules are in effect, what is the look back and how does it work?
So the look back essentially is what happens when you apply for Medicaid. With your application, you have to send in 5 years of records of all your financial accounts. The local county Department of Social Service will then audit all of those accounts, and they will flag any transaction where you gave away funds to someone other than yourself. That could be your child, it could be your grandchildren, it could be a charity. Anything that isn't to benefit you or your spouse, they total up. They take a total amount of that summed value, and then they divide it by what's called the penalty number or the divisor, which we'll soon see, which is the average monthly nursing home cost. And when you take the total number, divide it by that divisor, the result is equal to what's called the penalty period, or a period of time where Medicaid will not pay for your nursing home benefits.
So we're going to give you an example of that in just a moment. So it's a lot to take in, but know that anything, even innocent transactions, will be flagged. This is a full, very rigorous 5-year, 60-month audit of every account that you have, every canceled check that you have. And if you do not provide it, Frank, what happens?
They count it as a penalty, right? When you are applying for benefits, it's on you to show them that you did not, that you played by the rules, essentially. So if you didn't, then it's on you to prove that you didn't do something you weren't supposed to do. So that's why they take such a hard look at what you've done. And that's why they try to penalize you, because it's on you to prove that you didn't do something you weren't supposed to.
So clients come into us all the time and say, well, I haven't given anything away. I just put my children's name on the deed. Well, that's a gift. You've gifted the house to the kids, and that's going to come in within the 5-year look back. and you're going to have to get a valuation of the house, and then they're going to assess a penalty. Money gifted to a grandchild for college or for graduation, even gifts to your church can be penalized if they're large gifts, usually above $2,000, given at one time. So we do a 5-year audit before we file the Medicaid application, and we examine every one of those accounts and every one of those statements to make sure there are no surprises when that application gets filed with the county. There are some exemptions we'll talk more about later. A spouse or a disabled child, two of the major exceptions to transfers of assets, and transfers of the home, again, can be made to certain individuals. We'll get to that in just a moment. When they do this and they aggregate all of the transfers made during the 5-year look back, or soon to be for home care, the 30-month look back, how does it take the next step?
So that once you get the sum total of what you've given away, you divide it by these numbers that are now on your screen. So our office is in the Albany area, so we always typically look at the Albany number. So the Albany number now for 2021 is 11,689. So you take your total, divide it by that number, the result, that's your penalty period.
So let's take an example. The penalty number for months of is months of ineligibility. So it's not a financial penalty, it's a time penalty. So if they discover during their audit of your 60-month application that you gave away a total of $140,268 of assets, it might be just a house, it might be other bank accounts, it might be checks, they're going to divide that by the average regional rate, in our case here, 11,689, that's Northeastern New York, and you're going to be 12 months without Medicaid. In 2006, they put a very punitive rule in place to say that 12-month penalty period, even if you gave the assets away 4 years ago, that 12-month penalty period doesn't begin to run until you're in the nursing home, you're otherwise eligible, meaning you're below the $15,900, and you file your Medicaid application. That triggers the 12-month penalty. But how do you pay for 12 months if you don't have any more assets because you've already spent the rest of them down?
And that's the problem, right? Because now you're not an attractive person for that nursing home to take in, because you don't have the funds to privately pay for that year because you gave away all of your things.
So they trick up these Medicaid rules to trick people and to make it more difficult to qualify for Medicaid. We had this put in the law in 2006. We've been working with it and dealing with it ever since. Now we're going to be rolling out these new Medicaid home care rules, which are going to have lookbacks and penalties. A lot of very subtle nuances. Again, in 2 weeks, we're going to cover more of the home care rules with regard to penalties and lookbacks. Current home care rules, no lookback, no penalty until that trigger happens, July 1 or after. We can file Medicaid applications now, Frank, with no lookback. So March 15th, we'll cover the new rules, but up until then, you or your clients can file for Medicaid and get Medicaid in place for home care without any lookback, without any penalty. We can do the planning right now. We can create trust. We can set up transfers, and we can get Medicaid in place for home care virtually and literally the next month. So opportunity here, a window. They keep opening the window and closing it, but we'll find out what that final date is going to be for implementation. But until then, there are many opportunities with regard to home care, also coming with new rules for the medical qualification. And we're going to talk about that on the 15th. How to qualify, 5 ways basically, to get to Medicaid eligibility, that $15,900, or we'll talk about the spousal allowances for one spouse in the nursing home, one at home. You can spend down, you can transfer assets and wait out the penalty. You can do something called the rule of halves. You can utilize the exempt transfers or utilize something called spousal refusal. So let's take those one at a time. Spend down.
So if you need to spend some money on some stuff, that would be the time to do it, because we got to get you down below $15,900 if you want to apply. So what can we spend on? That prepaid burial funeral arrangement, that new car. If you're going to stay in your home and get care in, maybe your home needs some home improvements to make it more livable for you or more comfortable for your aides. You also can pay your professional fees. That includes attorneys. We wrote the law. It makes sense that we can get paid for those types of things.
So we send our clients literally on a shopping spree.
Mm-hmm.
Anything that you're going to need, basically for the rest of your life, buy it now. As long as you're buying things for full value. Now, we had someone who we heard about, not our client, who went out and came in with receipts for 5 television sets and 2 washing machines. That's clearly not for your own home. So it has to be for you. You have to be spending money on yourself, but at that point in time, you can repair your home, fix up the house, you can do renovations, put on the new roof, fix the sidewalk. All of that is kosher and it's all good, and it will all be spend down and not transfer. So attorney's fees, other professional fees, prepay them to the extent that you can, because those are legitimate spend down items as well. And then we get down to the 15,900. We still have non-exempt assets. What's next?
So sometimes we do this strategy where we transfer and then we wait it out. So if we want to do some trust planning, right, and we want to get you eligible down the road, then we create a trust, we fund the trust, and then you're kind of on hold. And then we just wait out the penalty that you would incur because you've created the trust and put things into it. And then once your period of ineligibility would be over, then we apply for Medicaid. So we're talking 60 months nursing home, 30 months home care once those new rules take effect, like Lou's been talking about. During that time, you can privately pay if you need some assistance. You can use that long-term care insurance benefit if you have that during that time period as well.
Now, we're going to cover the 60-month look back in the nursing home application in much more detail in 3 weeks. The 30-month look back and the home care, new home care rules in 2 weeks. And next week, we're going to talk about that Medicaid Asset Protection Trust. We build significant protections for you and design in tremendous flexibility to that trust so that even if circumstances change, you have an ability to change mid-course and follow a different path. We call it Plan A, Plan B, Plan C, but we're looking forward to what may happen during that 60 months if you cannot afford any longer to private pay for that time period. So join us for the subsequent sessions to get more detail on the trust and the other 2 applications. And this is the one that we have a lot of fun with, Frank, and that's the rule of halves.
Yeah, so this is kind of what we usually call our crisis planning. So this is the scenario where somebody needs care, they need care tomorrow, but they haven't done any planning previously. We've used this strategy since 2005 and 6 when they changed the rules and they put the look back in place for nursing home. So essentially, what do? We take all the money that mom or dad or whoever's applying has, we total it up, we do some calculations, and then we're able to save roughly half of their money from going to the nursing home. So we use half the money to pay the nursing home, the other half goes to the family, and we set up a penalty period on purpose where part of the money is used to pay through that penalty period. Because as you kind of said before, Lou, right? When we have that penalty, the issue always is who's going to pay during that penalty. We set up that half the money of that person is used to pay during that penalty period.
And we've been doing this, as Frank said, for 15 years based on these new rules. Let's take a look at a basic example of this. Someone comes in, and I've had clients come in that have been in the nursing home, their parent, for 2 or 3 years. They've private paid several $100,000. They have a couple $100,000 left. Let's say that they have $249,680 left of $500,000. They've already spent down the other half. That other half is gone. They should have come to us 2 years ago. But at this point in time, even though they've already been spending privately and they're already in the nursing home or someone facing admission to a nursing home, we take that $249,680 and we back out the $15,900. We will have spent all of the other things on prepaid funerals and burials and all those things in advance of this. This is what's left. And we're going to take it and split it, basically break it in half. So we do a calculation. We actually have software that does the calculation for us to make sure we get it to the penny, right? And so we gift half. That generates a penalty period. In this case, a gift of $116,890. If you divide it by our average regional rate, again, the number the state gives us, $11,689, you come up with a 10-month penalty. So someone's in the nursing home, they're $15,900 or less of assets. We apply for Medicaid. We show a gift of $116,890. They assess a 10-month penalty. We've loaned $116,890, and we've structured a promissory note to pay back monthly just enough to private pay the nursing home for that 10-month waiting period. At the end of the 10 months, the penalty period has expired. The promissory note has been fully paid, and we've been able to preserve, even at the 11th hour, that 116,890, or about half of the client's assets. Frank, there are, as we said earlier, exemptions to these rules that we can use
Right.
to
So,
plan.
so sometimes it makes sense to, rather than do the rule of halves, if we have someone that we can give things to free of penalty, why don't we do that? Because then we save everything. So if you have a disabled or blind child, you can give freely to that child, free of penalty, any amount of money. You also can transfer any amount of anything to your spouse. It's more determinative of whether you have that spouse to give things to. Your home also has some different exemptions to it. So if you have a caregiver child that's lived with you for 2 years prior to your nursing home placement, and we can prove that they medically provided a nursing home level of care, we can give that caregiver child your house free of penalty.
And most counties are pretty liberal with this, as long as the child has resided with the parent for those 2 years and done something, shopping, cleaning, assistance, transportation, all of those things, assisting a parent, keeping them independent, keeping them at home. Now they need a nursing home. That home can be transferred to that child without any Medicaid look back or penalty. Transfers to a spouse, you can always do. Those are exempt. And the other sibling with an equity interest is one we don't see very often, but if you're living with a brother or sister and they're helping to pay the mortgage, the taxes, etc., they develop an interest, you can transfer it. They only have to have lived there for 1 year under those terms. And of course, the other two, spouse and disabled child. So let's talk about spousal protections, Frank, because when you have one spouse in the nursing home, the law was changed back in 1987. The Medicare Catastrophic Coverage Act of 1987 changed the law to allow spouses certain additional exemptions.
Sure. So the numbers you see now, they're from the chart that I mentioned earlier that we were to come back to these numbers. So the CSRA, that's the Community Spouse Resource Allowance. That's the amount of assets that you can have if your spouse needs to go to the nursing home and seek Medicaid and you don't need Medicaid yourself. So that's capped at 74,820 under the new rules. There was a sliding scale that's going away. So we might as well not spend a lot of time on that because we're going to lose that. The minimum monthly maintenance needs allowance, or
Easy for you to say.
MNA, that's the amount of income you can have when your spouse is in the nursing home. Again, you're at home, you don't need Medicaid. That's your income allowance, $32, $59, $50 each month. Your home is exempt as long as you or your spouse live in it, like Lou said before. So if you're in the home, your spouse is in the nursing home, as long as you're in the house, they can't touch your house. The IRAs are always exempt as long as they're in payout status, like we mentioned earlier. And you always have to remember, when you have that community spouse, you can always transfer things to them free of penalty.
And what if the spouse is over the allowable income and assets? In New York, we've survived 26 attempts to do away with spousal refusal, but it still exists. So you can actually transfer all of the assets to the well spouse. They are exempt transfers under the rules. You can then apply for Medicaid for the ill spouse, and the well spouse can just say, no, I need those assets to live on. You get Medicaid immediately for the Medicaid applicant, but there is a right of recovery that you need to be aware of against the community spouse who has excess resources. That said, we've used spousal refusal on a number of occasions. We used to get a lot of claims by the county against those spouses. They kind of died down. I'm understanding downstate in the New York City market, they're starting to come back. So you just need to be aware that the game isn't over when you use spousal refusal. So those are the basics of eligibility and the 5 methods of how to qualify for Medicaid. Again, we're going to make this presentation available to you so you can refresh your recollection. And what we have talked about today, we're also going to be following up in more detail on each of these topics. The Medicaid Trust, such an important tool, something that has been a staple of the elder law practice for many, many years. And we're going to go through that in detail. Next week on Monday and March 8th, we're going to talk about Medicaid home care on the 15th, nursing home care on the 22nd, and then appeal rights, advocacy. What if you're denied? What if the county doesn't get it right? How do you appeal that, and what are your rights on the administrative appeal level? So we're going to cover all of those topics in the future. If you have questions from today or any other questions on this topic or any topic related to what we do, please email them to info@pierrolaw.com. And you can always get information on upcoming programs at that same website under the events tab. And with that, we'd like to thank you for today, and we will take those questions by email. I think we came pretty close to 30 minutes. Thank you for your attention. We hope you can join us for the rest of this series. And please tell your friends. We'll be doing the next 4 sessions over the next 4 Mondays, and they will be posted to our website. Thanks again. Frank,
Thank you.
thank you. And Beth, thank you. And hope to see you all again next Monday at noon. Have a great week.